about a 30, 45-second delay for out of TV land.
He said he just pressed start, so it's about a 30-second delay.
Right now.
So we are currently live.
But you're not up. I don't have it yet. As soon as
It's coming.
here it comes. Okay, I've got it. All right, let's. Is anybody opposed to getting this meeting started since we have a quorum?
No.
No. All right, Caitlin, will you call the roll, please?
Yes. Commissioner Jeff Diaz. Commissioner Rick Douglas.
Here.
Commissioner Marcia Franks.
Here.
Commissioner Diane Hills.
Here.
Commissioner Austin McMullen. Commissioner Fontaine Taylor.
Here.
Commissioner Bobby Wood.
Here.
Chairman John Grease.
Here.
You have a quorum.
So we have a quorum. I would like also the record to reflect that Chief Counsel Bernard Mickens is here, Assistant General Counsel Anna Matlock is present, Caitlin Maxwell, Executive Director of the Tennessee Real Estate Commission is here, as well as Ross White, Education Director for TREC. If the commission will allow me, I'll give you a quick overview of why we're here. Excuse me, and what I hope we get accomplished. Legal department, and I'm paraphrasing what I believe to be true, does not necessarily dispute the action we took regarding D&D School of Real Estate at our February meeting, but there is apparently some concern about due process and the procedure. And so I think Denard will speak, at least Denard will speak about this issue. And at the end of our conversation, it's my hope that we have two motions. One motion would be to reverse the action we took against related to D&D School of Real Estate, and then figure out a motion that puts it on the agenda for a future TREC meeting that makes legal comfortable as far as the process goes. So with that background, Denard, are you ready to speak to us?
Good morning, commissioners. Before legal puts on its presentation, we're going to have a short statement of necessity from Anna Matlock. When we have these telephonic meetings, we kind of have to go on the record as to that you all agree that it is important for us to be here today. And so Anna's going to read a short statement of necessity, and then we would need a motion for you all to adopt it, and then we would go forward. Okay? And so here's Anna.
Okay. Good morning. This is an emergency scheduled meeting of the Tennessee Real Estate Commission, which is taking place in Conference Room 1A of the Davy Crockett Tower in Nashville, Tennessee. Notice of this meeting was posted to the Commission's website on Wednesday, February 27, 2019. As there is not a physical quorum present, a statement of necessity will be read into the record and filed with the Tennessee Secretary of State as required by statute. Pursuant to Tennessee Code Annotated Section 8-44-108B2, which states, if a physical quorum is not present at the location of a meeting of a governing body, then in order for a quorum of members to participate by electronic or other means of communication, the governing body must make a determination that a necessity exists. That determination must include a recitation of the facts and circumstances on which was based. Further, Tennessee Code Annotated Section 8-44-108A3 defines necessity as matters to be considered by the governing body at that meeting require timely action by the body, that physical presence by a quorum of members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. As stated, this is an emergency scheduled meeting of the Tennessee Real Estate Commission. The purpose of this meeting, with members attending my teleconference, is to discuss approval of post-licensure printed correspondence courses for D&D School. Voting will be conducted by roll call. If you do not believe that you can remain impartial while reviewing this matter, it is appropriate to recuse yourself from discussion and voting. We will now need a motion and a second to adopt the statement of necessity.
I make a motion to, I second.
Okay, so who made the motion?
Marcia?
Marcia made the motion and Fontaine seconded.
Yes.
Okay. All right, we're going to vote on the motion to adopt this recommendation from legal. It'll have to be by roll call. So if you're in favor of the motion, and Anna, what's the document or?
It's a statement of necessity.
Statement of necessity. You'll vote aye. If you're opposed, you'll vote no. And if you have a conflict, you'll abstain. All right. Caitlin, will you call the roll, please?
Yes. Commissioner Rick Douglas.
Aye.
Commissioner Marcia Franks.
Yes.
Commissioner Diane Hills.
Yes.
Commissioner Fontaine Taylor.
Yes.
Commissioner Bobby Wood.
Yes.
Chairman John Grease.
Yes.
This is Austin McMullen.
Man. We're in the middle of a vote, Austin, so you need to call Austin's name and have him do what he wants to.
I'll listen.
I don't know if Austin can accurately vote since he didn't get to hear.
He
So-
can pass or recuse himself.
We'll have a 6-0 motion with one abstention by Commissioner McMullen.
Perfect. All right, Denard, is it your turn?
No, I'll actually take over. So
Okay.
this emergency meeting was called because of the motion at the February 2019 regular scheduled commission meeting. The D&D School is supposed to lose approval of their post-licensure printed correspondence courses by March 1st, 2019, which is today. Tennessee Comp's Rules and Regulations 1260.05.10 allows the Commission to take the action of withdrawing approval. However, we believe that the process for this was flawed. The action was taken without the party present or invited to the meeting. Also, I would like the Commission to consider the fact that this action could impact many providers, the industry, and commerce, and with that stated, we believe that it would be more appropriate to take more time to study and find out the issues regarding this. So the board is allowed to set the standards, and if you believe that testimony once a school is to appear before you falls short of the standard, we believe that this needs to be addressed in a more universal manner. And as we said before, this could benefit from more time and study. So we believe that the earliest time that this school should come before the Commission is the April meeting. Generally, we would like individuals to get a month's notice, at least 30 days, to appear, so they'll have time to think and prepare a statement and appear before the Commission. Even though this will not be a contested proceeding, this is just to give them the opportunity to gather their information and come before the Commission. So that's basically what we have here for you to consider for your discussion. If you have any questions, please let me know. I'll be willing to answer those.
Okay. So, Denard, do you have any further comments?
This is Denard. Not at this time. I think Anna summed up the crux of why we're here today. And if again, as Anna said, if you all during your discussion have any questions for legal, we can answer those.
All right, John, I have something to say.
Okay, Fontaine.
The D&B came before us in January and gave their statement. We waited until February after we asked several people to do studies on this and come back to us with their fact finding. we heard this on February, although D&B was not there, and made the motion that we did, which I wish someone would read to us what their motion exactly was. Can you read that to us, Caitlin?
Let me see if I can pull up the minutes.
The motion at the time was to withdraw approval of all printed correspondence courses by the D&D school effective March 1st, 2019. That motion was made by Commissioner Wood and seconded by Commissioner Franks.
All right. So I think we have had plenty of time to look at this and study it, and it is quite clear that the 62-13-325 D3 has not been followed at all. They have not gone along with and the D3 reads no, it's B4, B3 and 4. If the class provides, the comprehensive course, let me get it straight. It contains at least 6 written exercises that are to be submitted periodically to the instructor, graded and returned to the student. And if the class, now that's the and, but it's graded and returned, and it is obvious that that is not being followed. So after study and after D&D's meeting. So I think that they have had time to do this, and I think we've given them due process.
All right, Fontaine, thank you. Bobby, did you want to speak?
Yeah. My thought was, so are we saying that if we would have done it in January, it would have been okay, but because we waited till February and thought about it, it wasn't okay?
Well, Commissioners, this is Denard. It's not the idea that you took time to think about it. Obviously, we support considered deliberation. Legal's concern is more that from a due process standpoint, in January we invited those D&D, this particular provider, to come before the commission and state their case. At that time, the commission refrained from taking any action, and we were going to discuss moving forward how we would do more of our fact finding. In February, we put the issue back on the agenda, and at that point, Legal was presenting its case or its plan for how we would gather our fact finding, and at that point, the commission decided to act. And it's Legal's analysis and standpoint that a more fair, a more fundamentally fair process would be to put D&D school on notice that the commission was going to take up the particular instance of their offering of classes generally, and allow them the opportunity to appear and state their case. After the January meeting, for instance, we don't know if they took any remedial steps, if they had plans to do any remedial steps. And in addition, just as a side note, part of D&D school's presentation was that many other schools in the industry follow the same pattern and practice, and so part of that would be that we would need to know more, and as Anna had stated earlier, the commission does have every right under the statute and rules to set the standards by which courses will be graded, and so if the board wanted to take the time to create a more universal standard, that would also be appropriate, and so that's just Legal's analysis and review, in that this particular process was was flawed, and that we should allow the provider, this particular provider and providers generally, the ability to come before the board and state if they have taken any actions to address the board's concerns, the board's stated concerns from the January meeting.
Bobby.
But I think they did get a chance. I mean, they got a chance, and they came to January, and they're the one that cooked their own goose. They're the one that was saying that they weren't doing any of these things like Fontaine was talking about. I mean, and their defense was two defenses. One, this is how I've been told to do it, and two, everybody else is doing it. And the problem is we don't have evidence that everybody else is doing it, so we can't get everybody else right now. So we only have evidence that D&D did it because they told us they were doing what they were doing. So I don't know what them coming before. I mean, let's say they come before and say, we're sorry, we got caught, we won't do it again. I don't know if that's going to change our decision.
And
I mean, they got caught.
Rick Douglas.
Go ahead.
I'm sorry, you go ahead.
No, that's fine. Commissioner Douglas, proceed, please.
Okay, I was just going to say, Denard, you were talking about us making maybe writing a more universal set of rules. I mean, what's more universal than 6213, 325? I mean, it applies to everyone, and apparently D&D did not meet the requirements.
Well, Commissioner Douglas, this is Denard. When I say universal, I'm referring more to the application rather than the rule itself. I agree, and I think legal analysis agrees with the board's analysis. The board absolutely has the ability to take out the action that it did. However, it is our thought, our analysis that the commission's action could be done in a more systematic way, and part of that would be allowing D&D schools to come back and see if they have taken any remedial steps, and in the meantime, legal would proceed with the plan that we set forth in February, which would be reaching out to the industry and making sure we have to do some more fact finding. We wanted to present our plan to the board in February, and we're still planning to do that. Reach out to other providers of printed correspondence courses and make sure to follow up on this particular provider's allegations that this is the state of play in the industry. And in that point, I think that if the board were amenable to bringing this issue back in April, we could have a fuller discussion about a standard generally and make sure, based on the responses we get from the industry, that make sure if D&D's allegations are true, and then B, how does the board want to address it universally? And that's sort of what we're getting at. It's not about making a more universal statute or rule. Like, as you pointed out, the rules and the statutes are pretty clear. The issue is just the application, and it feels very piecemeal. And I think that the board could take the opportunity to just create one standard that everybody can adhere to at a certain date, if that makes sense.
Denard, I think we did that. We did talk to our education director, Ross Lynn. We gave him advice on how to make sure this did not happen again. I think we made a plan for that. And I think we've already covered this and been very fair about this.
And this is Marcia, after the January meeting, I'm thinking, Bobby, after that meeting, didn't you acquire one of their tests that still had the answers to the back of it?
Yeah, I mean, even after the course that got them in trouble was their ethics course that D&D sent out. And then they turn around and sent their core course out in January, did the exact same thing. And that was after they come to see us in January. So even after they came before the commission, they didn't change nothing. And I have proof of that. I didn't bother to send it to the commission but I got proof of it because they emailed it to me, which was silly. After they'd already been
It
before
was
the commission.
emailed to me too. This is Diane Hills, and it was emailed to me. I guess I've just I had not opened them before, and on taking the advantage of the courses, but I did then because it caught my attention, and there it was.
So I'm thinking that, first of all, our council was sitting with us in the February meeting and didn't mention that there was any problem. That's number one. And number two is we all each took an oath to protect the public. And here we are now at an emergency meeting trying to give this company a chance that we've never given anybody else. An emergency meeting so that they could continue sending out their tests with the answers. This is a no-brainer. It was a unanimous vote, and I think they've been given more due process than anyone we've ever given due process to. And I really don't see the reason with two attorneys sitting in the room with us why somebody didn't say, wait, you've got to do it this way.
No.
Then we would have done it that way. But we've already taken a vote, and because it was to protect the public, I don't see any reason to reverse it.
Commissioner Franks, I would like to interject. During the meeting, it was stated several times that we believed that a blanket removal of all courses would not be an appropriate action, and we also requested that the school come back to present before the commission. It is an issue of fundamental fairness that we would have them appear before the commission to make their stance. And while you guys have mentioned emails, we do not know we know when those emails were sent, but that information was not provided to us prior to the meeting, so we did not know about that information at the time.
Emails? What emails?
The emails that you, that Commissioner Franks and Commissioner Hills mentioned receiving, that information was not presented to us until the meeting. And during the meeting, I would also just like to state on the agenda, this was not part of the agenda at that time. The agenda was to discuss generally about printed correspondence courses and how we would take that in the future. So that is the issue. We stated several times that we believe that it would be a good idea for the commission to have the school reappear before in a meeting.
So this is Commissioner Hills. Just for clarification, when the school showed up at the January meeting, and I don't recall that it had been on my agenda. It may have been on an updated agenda when I arrived, but it wasn't on mine to look at that I recall. They came on their own accord. We invited them because a complaint had been filed and had been identified. If somebody could just make that clear to me, why they were there that day and how that got to be.
They were there because there was essentially a complaint filed, and they were given notice and asked to appear. They came on their own accord. They didn't have to come. But I think part of the issue is that at the January meeting, the commission left it as we need to address these courses as a whole. We need to figure this out as a whole. It wasn't like quit doing this or else. I think at the January meeting, we left knowing that we needed to do more research about what was happening with pencil and paper courses and correspondence courses. I don't know that there was a clear...
I would also just like to interject that at the January meeting, it was posed to the commission whether an action would like to be taken, and the commission deferred not to take any action at the January meeting while the school was present. So,
have we heard the case?
The reason we took no action is we wanted to make sure what was going on, why, with not only with other people, but Ross was to do a study about what was going on, and was anybody checking any of the courses that were being given? And the answer was no, they weren't.
It was not.
And there's not been anything filed against another school for the same action. And also, Ross, he gets the syllabus. I'm wondering, Ross, did they include the question and answers at the back of their syllabus when they turned it into you?
In the original documents, when they turn in a submittal, it would have been with the manual that they use to teach from.
But it's
not a test.
This is Commissioner Hills. I would think on that point, if our education director received it and received the answers, I don't know that would send up a flag that they identify that they send it out. It may just have been that they send it in to the education director. So my question is, so does this have a case number, and has it been read into record for us already?
It is not.
Commissioner Hills, this is Denard. Could you just repeat that question? You wanted to know which. What was the question? I'm sorry.
So when they appeared in January, and they decided to come and appear and state their case, has the case number been assigned? Has it been read into the record for us to address it?
So
that's the part I'm a little confused about on our timelines.
As it was explained in January, we do not have a set procedure for how complaints against schools are handled. Because schools are not like licensees, it does not go through a complaint process. So we decided that it would be best for the school to appear before the commission and state their case. So no, a complaint number was not presented because one was not assigned. It was just a general complaint that was brought before the commission at that time.
Okay, because it's only the schools are not identified. It's the instructors that are identified.
Correct. If you remember, it is the instructors and the courses that are licensed with the commission, not the schools.
And that's what we voted on, was their courses there that were pen and paper courses. We didn't vote on the school. We voted on their pen and paper courses.
Right. And I would just like to state one more time, when we left the January meeting, it was the understanding amongst the education director, the executive director, and the legal counsel that we were not at that time doing a fact-finding mission for this particular school. It was proposed that we bring back a plan before the commission of how we would like to proceed in general for printed correspondence courses. We were not looking specifically at this school since the issue was deferred in the first place. So it is not, I think there was something mentioned beforehand that Director Ross did not look into the school. Well, that was not what we interpreted as being told to us. So
what did you interpret it to be then?
We interpreted, what we did was we had a meeting and we discussed it. We discussed how we would like to look at printed correspondence courses in the future in general, since we saw that there was a fundamental issue. And at the February meeting, we decided that we would like to take a survey amongst the schools, see what the issues are about the industry in general, get some more insight to see about these other things that were brought up by D&D School, if that was actually occurring by other individuals. And then we would like to have a discussion with the other schools to see how we can get the schools into compliance with the rules and statutes. If this is, although we only have a complaint against the one school, it seems to be, by their testimony, an issue that is more universal. So I believe targeting one school is not necessarily something that the commission should do. But
you've not had any complaints about any other schools. There's no evidence of any other school doing it. In January, you were going to look at it. In February, you were going to look at it. And now we have an emergency meeting, and you still haven't looked at it. So
in February, we did look at it.
How much longer do you need to look at it?
I think the argument is that to collect this industry-wide, there'd be more time would be needed than just 1 month, you know, to look at it as an industry
but that
whole.
started in January. It's now March.
Right, I understand. I would like to just interject and say we did come with a plan for the commission of what we would like to do in February, and the commission decided not to vote or even listen to that plan. No motion was made for us to do anything in February at that time.
I don't recall you giving us a plan at all.
Executive Director Maxwell did for Commissioner Franks.
I didn't get a copy of it.
Your rationale is that because nobody else is found doing it, that's the same rationale that we would take with any agent coming before the Real Estate Commission, that we couldn't make a determination unless everybody else didn't do it. That's not a rationale. The rationale, they gave their testimony, we heard what they did and didn't do, and we made the judgment on them because we knew it. Anybody else we find out that's doing it, we'd be happy to hear about it.
So if I could jump.
Okay.
And I've got to go. So.
Well, let me try to summarize here for just a second. When I was asked to call this special meeting, it was basically, as briefly as I can stated that legal didn't necessarily disagree with our decision. They were just concerned about the process. And the process, in their opinion, had the possibility to be appealed or challenged. And so, for an abundance of caution, the goal was to put this off so that they get comfortable with the process.
Yes.
And Anna, let me just finish this. And that's really what's in front of us today. If you agree that or concede to legal that the process might be flawed, you'll agree to put this off till April. If you don't, then the motion will fail and will be done. But that's the process. It's not trying to decide who's right or wrong on this thing. It's just about the process.
John,
we'll go ahead and take a vote.
Well, shortly we will, but I just wanted to tell you why we're doing this. It's not because we made the wrong decision. We might not have followed the process legal is comfortable with on a long-term basis.
But John, we've already taken an action. And so what could happen today is that we not reverse that action, and legal can do their due diligence and look into all the other schools there are and see if there's any reason to change the way we do things. So we can just leave it the way it is, and if legal wants to present something to us in April, then they can do that.
Absolutely. You know, as I stated when I got started on this meeting, I'm looking for a motion that would first reverse the action Commission previously took related to D&D Real Estate School, and a second motion, if that passes, to schedule a April agenda item related to D&D Real Estate School.
Chairman,
so,
question?
Mr. McMullen.
Just to refresh my memory, this, as I understand it, initially came up because of these tests being emailed out, soliciting people to sign up, and we got information based on those emails that the answers were being given along with the test that was supposed to be done, and that seems to violate the statute that Fontaine talked about. And so my understanding is that the people from the school showed up at the January meeting, and at that time, this is really where I'm getting with my question, did they admit during the January meeting that all of their tests are like that and that the answers are sent out with all of their courses?
No, that was not admitted.
Okay.
All right,
so
right
now, we have at least one or two courses that we know the answers are being sent out with. Is that right?
That's correct.
So would it be appropriate to take away the approval of those courses and to set further consideration on all their other courses for maybe the April meeting, along with a report at that time of the staff's investigation of whether other education providers are also sending out answers with their courses as well?
That's certainly possible. I think it would be possibly a good idea for the commission to only consider the certain courses that we've received complaints from at this time, those specific courses, as we don't know the information about all of the other printed correspondence courses.
And I think that what we were trying to do was any course that was sent out with answers, we were trying to make every person follow the rules that are already written, whether it's one course or 65 courses. We follow the rules that are already written.
Commissioner Taylor, just to be fair, though, that wasn't the motion. The motion was to remove approval for their post-licensure courses because the rationale being that pre-licensure courses, the person, even if they got the answers, would still have to pass the real estate broker exam. But one thing that I think that was brought up actually by you for Commissioner Wood's motion was that in the rules, a correspondence course that gives more than 8 hours of credit has to have an exam. And you asked Commissioner Wood if he would like to change his motion, and he declined to do so. But the only reason I bring that back up is that we don't know, as far as I can tell, whether the 8-hour plus courses are actually being graded via exam. So if that being the case, I think that Commissioner McMullen's suggestion that perhaps we could remove approval for the courses that we know about, that we have direct evidence for right now, and then put them back on the agenda in April. That will give legal the amount of time that we need to reach out to the other providers that we know are given printed correspondence courses, and then in April we can have a universal discussion about all of them, what is the state of play in the industry, and see if D&D has any further answers for the commission. I think that based on everything that I've seen, I think that sounds like a good compromise with what's going on today.
All right. Would you like that motion, please?
I'll make a motion, Chairman.
Yes, Mr. McMullen.
I second.
Oh, well, she got let
He's going to make the motion.
I know. I think thought I knew.
My motion will be that we continue the revocation of the approval of the courses from this provider that we know are being sent out with the answers to the test to the students. I don't think anybody's going to sit here and say that they think that's the right way for this to be done. So the courses that we know, that revocation will continue. The other revocation that was approved in February of all their courses, we're not going to do that. We're going to put everything on the agenda for April as to the remainder of this provider's courses, and we would expect staff to come in April with a good report to us as to what the state of the industry is. Are there other providers out there that are sending out answers with their materials? And if we find there are other courses and other providers that are sending out the answers, I think they need to be aware of that meeting, and they need to know that at that time the board may consider revoking approval for those courses or possibly for all of their courses. That's my motion.
Do you think we need to name those courses?
So, Diane, did you second Austin's motion?
Yes.
Okay, so motion's officially on the floor. Now, Fontaine, do you have a question?
No. Do you think we need to name those classes?
Yes.
That we know for sure?
Specifically, it was the ethics class and the core class.
All right, then. Okay.
Okay, that's the motion in front of us. Is further discussion?
Yeah, this is Bobby.
Hey, Bobby.
I just want to make sure we understand. I don't. And Denard was right. We were only talking about post-licensing courses, and the rationale was not because I necessarily thought that they were doing everything else right and only post-licensing. I was just trying to show them some grace and not trying to shut them down. But the other part of that was, too, when they gave their testimony, as to they did not say, hey, it's only ethics courses that we're not grading and not doing this. They said, she said, we don't do it anything. She never specifically thinks. So she was basically testifying for every class they do not grade. And the only time she said that they ever question it when somebody sent the answer sheet back blank. And that was the only time they questioned it. So her testimony was they do it for every single class and not just post-licensing classes. So I think we're wrong if we want to just try to pick which classes. And I think we're wrong in basically these people got caught. They came and testified that they weren't doing it by the rules, and their explanation was, well, everybody does it, and now we think we have to go on a goose egg hunt because of that. They said that. If we went and opened up some big kind of fact-finding mission for everybody that got in trouble and said everybody else does it, that's all you'd be doing. Because I'm sure that happens a lot when you get a complaint in. They say, well, everybody else does it this way. So I don't think that matters at all. And then the final thing.
Bad precedent.
Well, and the final thing, we keep talking about April. Can we not have any of this stuff where we can address it and where they can come to us in March?
Well, I think, Denard, you can speak to that, but it has to do with due process.
Okay.
Yeah, right. Yeah, yes, Chairman Grease. The thinking about pinning it to an April date is twofold. One, course approval is not covered under the discipline of Section 312. That is something that's different. It's a different power that the board has. So it wouldn't be that a complaint was opened. We're thinking more, but the thrust of the UAPA is basically that most people have 30 days to respond to allegations against them. So in keeping with the general thrust of the rules and statutes, is legal's opinion that 30 days would be appropriate for them to go ahead and create whatever defenses they're going to create. And it also gives them a date certain on which they can come. They know that the board's going to take it up, and then we will just handle it at that time. Additionally, having it at the April meeting allows legal and Ross and Director Maxwell to get together, as we had discussed already, and go ahead and move forward with our plans to look at the rest of the industry. I take your larger point that this is a little bit different than how we would process, say, a reasonable skill and care case against a broker, but it's because it's in a different part of the statute. So that's where the difference comes in. But that's the thinking and the legal opinion of the legal department, is that 30 days is basically what we usually give people. It's too late for 30 days to get in March. We can do it in April, and that also gives us the time to do the fuller survey of the industry at that time.
Chairman?
Yes, Mr. McMullen.
I would say that at the March meeting, although we're not asking providers to be there or this provider to be there at that meeting, I would like to hear a preliminary report at the March meeting from our staff, particularly Caitlin and Ross, with respect to what the plan is and what the course of action is that they're going to take, or maybe that they've already implemented, as to figuring out what else is going on in the industry. And I think we ought to at least get an interim report at the March meeting as to what steps they're taking and anything that they have already learned by that time.
Okay, other comments?
This is Commissioner Hills. But my reason for supporting the motion is to try to err, because the due process, I don't have it lined up in my head, even though it's just been explained that it is a little different. That's the only reason, because it needs to be addressed. And I have all the faith in the world we will address it as commissioners, but I don't want some loophole.
Other comments?
So the motion is that we can not reverse it, but change the action or we can vote no that we want to keep our decision
Yep.
from the February meeting.
Correct. If you vote yes to Austin's motion, you will be voting to partially rescind the action taken against D&D schools and include on our April agenda a formal line item on our agenda related to D&D schools courses. If you vote no, you're satisfied with the action the commission has previously taken, and we'll let the chips fall where they may and let legal defend us if we need to. And that's how I see this vote. Are you ready?
Rick Douglas?
Are you ready to vote? Yes, Rick. Go ahead.
I was just curious as to whether there's pressure from outside the purview of the Real Estate Commission to look further into this matter and to apply, as you stated earlier, an abundance of caution with regard to this issue.
Let's say that the chair has probably not had any pressure, but I've had some discussions.
I would
And
just
with the
like.
new-
Go ahead.
Stand by, Anna. With the new administration, there's probably some concern that it's better to be cautious than to be aggressive until we get to know the new administration a little bit better. That's all I have to say about that. Anna?
I would just like to say we have not heard any of that information from the legal department. We wanted to bring it before the commission because we were, as you saying, operating under abundance of caution and would not like an action such as this, which has never been done before, to expose the commission to personal liability for this decision. So this is the main reason we brought this to you before in an emergency meeting.
Okay, and I maybe shouldn't have said pressure, but maybe advice would have been a better term. But okay, that's all. I'm in favor of the motion, so I'm ready when you guys are.
Any other comments? All right, if you're in favor of Austin's motion, when your name is called, you'll vote aye. If you're opposed, vote no. Caitlin?
Okay. Commissioner Rick Douglas.
Yes.
Commissioner Marcia Franks.
No.
Commissioner Diane Hills.
Yes.
Commissioner Austin McMullen.
Yes.
Commissioner Fontaine Taylor. She might have had to leave. Commissioner.
I know. I'm yes. I guess yes.
Commissioner Bobby Wood.
No.
Chairman John Grease.
Yes. That motion passes. And as far as I'm concerned, the motion incorporated what I had second on my list to schedule it for April. So staff, Caitlin, Ross, Anna, you all believe it's on the agenda for April, correct?
We will put on the agenda for April, and then we'll also provide a preliminary update at the March meeting.
Perfect. Anything else to come before this commission? All right, I hear nothing else. Is there a motion we adjourn?
So moved.
Thank you all for participating. I know you've got things to do. You're busy people. I appreciate your commitment to this industry. You all have a great weekend.
Thank you.
Thank you.
Thank you.
Everybody have a great weekend, everyone.
Thank you. Bye.